Court Order 14 District Texas now set. Soon to adjourn. I'll say the Constitution court.
Please be seated. We have one case on the docket today, Ricardo Olivares versus the state of Texas, 1421-491 CR. Can we get an announcement of counsel, please?
Yes, Dossie Schindler from the Harris County Public Defender's Office with Mr. Olivares.
Are you reserving any time?
Yes, I've reserved 5 minutes.
All right, thank you. Okay. Hopefully there's a microphone up there.
I'm sorry?
Is there a microphone?
There is,
okay,
unfortunately.
Good.
No, I'm just kidding.
Can't see it.
May it please the court. In the early morning hours of October 15th of 2017, Mr. Olivares placed a 911 call requesting police and EMS services to come to his house after an altercation with his then common-law wife had resulted in a shooting. Police arrived at the scene very quickly, and Mr. Olivares immediately gave them consent to search the premises. He told them exactly where Ms. Cardona was located and also where he had left the firearm. Mr. Olivares was handcuffed, his hands behind his back, and placed inside a locked police car. Several hours later, as he remained in the locked police car, the lead investigator in the case, who was Detective Francisco Garcia, approached the patrol car and asked Mr. Olivares to participate in a walk-through interrogation. Detective Garcia made no attempt to obtain a waiver of Miranda rights despite knowing that Mr. Olivares was the one who had placed the 911 call and that he had been present at the scene during the shooting. Detective Garcia will testify that Mr. Olivares was detained for investigatory purposes and is not under arrest. But investigatory detentions are based on reasonable suspicion, and reasonable suspicion only lasts until the individual can either be eliminated or included as a suspect. Here, Mr. Olivares was a suspect the minute he placed the 911 call and admitted to being present at the scene. In Dowtiff, which is a pivotal case in this
Let me ask you, counsel, what is the harm that came from the statements that are trying to be suppressed from the first encounter?
Well, it places him there. It creates a situation where he's going to feel compelled to elaborate on his involvement in the shooting, and without having been told that he has the right to counsel and the right to not speak about the instance of the shooting.
And I understand there's some exculpatory value to it, is there not?
Possibly, but I think he would need to have counsel in order to determine what exactly that might be.
Okay.
Well, at trial, didn't he rely upon the walkthrough statements as exculpatory evidence?
Well, his defense was that it was an accident and he was trying to get a verdict of negligent homicide. But nonetheless, his statements changed over the course of these interrogations, and that made him look dishonest. So,
yeah, but the walkthrough statement gave some opportunity to argue for some lesser offense, and by excluding, if the trial court had excluded the walkthrough statement, then there would be no evidence.
Well, that would be ideal.
No evidence of other than there would still be his evidence in the custodial statement that he made, assuming that stayed in.
But it didn't. The trial court did not admit the custodial statement.
Well,
that was.
You're talking about the post-Miranda. I'm talking about the pre-Miranda.
Okay. Well, I argue that all 3 of his statements that he made were custodial. And it's one thing to say that his statements could have been used as a defense. It's another thing to have those statements made to law enforcement, as opposed to relayed to his defense counsel and given the opportunity to present them, in a strategic manner.
I think the focus of the question is that statement that was admitted gave an opportunity for a defense. Are you saying that the statement should have been suppressed, and that in that way he would not have suffered any harm?
Well, if the statement had been suppressed, then if the trial continued, having very little evidence to support a conviction, he could have testified and presented that as a defense without all these other versions that he gave to law enforcement coming in. So it could have been used as a defense through him, and he could have given that explanation in his attempt to obtain the negligent homicide verdict, through counsel. But instead, all these versions come in that he relayed to law enforcement without ever having the opportunity to, know what his rights are.
So are you saying that if all three statements had been suppressed, that would have been beneficial to him?
Absolutely.
But if one or more were not, then it was detrimental to him?
Yes. Because it didn't allow him the opportunity to present his case through his defense counsel. Instead, it gave the state the opportunity to present the case through un-Mirandized statements that he made while he was clearly in custody. So again, I was just going to point out that in Dowtooth, the pivotal moment when that long investigative detention became a custodial interrogation was when Dowtooth admitted that he was at the scene. So law enforcement questioned him for 12 hours, and the minute he said he was at the scene, they said, okay, this is no longer an investigative detention, no longer based on reasonable suspicion, but rather this is a custodial interrogation based on probable cause. And that's exactly what happened here in the 911 call. He said he was there. So they had probable cause to arrest him from the very beginning. And I would just point out that although Detective Garcia will consistently use the word voluntary, voluntary, voluntary ad nauseum, just because he says voluntary does not make it so. And in Cavazos versus United States, the Fifth Circuit held that an agent calling an interrogation non-custodial is not talismanic and does not mean that the interrogation is not in fact custodial.
Well, are you disputing that Officer Garcia informed the defendant that this was voluntary, that if he made any statements, they would be voluntary?
I think he did say voluntary, and I think he used that word intentionally to mislead Mr. Olivares and to avoid Mirandizing him.
But didn't he also repeatedly say you're free to go?
No, he was definitely detained, but they say he was detained for investigative purposes and not custodial interrogation. So he wasn't free to go. He was handcuffed in the back of a police car.
No,
So I don't know.
okay, I've now shifted over not to the police car.
Okay, so during the walkthrough, he was still detained.
Not on the walkthrough either.
Okay, sorry.
I'm focusing on the statements made at the police station pre-Miranda.
Well,
Wasn't he there repeatedly told that he was free to leave?
he was told that he was free to leave, but that does, like they say in Cavazos, that doesn't make it true. I mean, he was in a police station. He was trying to, his whole intent all along was to explain his confession that he'd already given. So it's not like he's going to say, okay, I'm going to leave now, bye, I'm going to Starbucks, I don't want to talk about this anymore. That wasn't going to happen. Although he's not handcuffed in the police station, he can't just wander around.
But it's not as if he didn't have that option if he was informed of that option, correct?
Well, I mean, in Cavazos, they tell the defendant in that case, you're free to go, we're at your house, but you don't have to participate. And the Fifth Circuit says, no, it's unreasonable for anyone to come to that conclusion under those circumstances. And that's like here, a reasonable person who had confessed to being at a shooting, who'd been handcuffed in the back of a police car for hours, would not feel like they could really leave. They would not feel like they weren't obligated to continue to explain their confession. And also, any reasonable police officer would believe that they had probable cause to arrest at this point. So, it's not the subjective intent of either of those individuals, it's what is objectively reasonable. And any police officer will say that once the suspect has admitted to being present at the scene of a shooting, they have probable cause to arrest them. And the worst part about it is that later on, Officer Garcia, or Detective Garcia, admits that he strategically did not Mirandize, and he strategically prevented or continued on with the interrogation without Mirandizing him as a way to get around Miranda. He says during the motion to suppress hearing, when defense counsel was questioning him, he says, the defense counsel asks, and you questioned him about the shooting of Miss Cardona? Yes. And you did that to solve the case, right? Yes. Okay, so you immediately get information from Mr. Olivares, as much information as you could to solidify the fact that this was a homicide, right? Yes. So you chose to question him first and arrest him later? Yes. And that's a strategy that is often used by police, right? Yes. So he admits that he purposely tried to get around Miranda by not considering it custodial and by throwing around the word voluntary in order to get as much information out of Mr. Olivares as he could without obtaining a waiver of the Miranda rights. And so for that reason, it seems pretty obvious that all of the statements that Mr. Olivares made were custodial and should have been suppressed based on the fact that law enforcement deliberately attempted to circumvent Miranda in this case. Any questions?
May it please the court. Admittedly, this is a very convoluted case, and it's further complicated by the fact that if you review State's Exhibit 138, it does show that the defendant was actually Mirandized by Deputy Clark before any of the statements are made. This doesn't come up at the pretrial suppression hearing.
I'm sorry, what's the reference for that?
State's Exhibit 138, which has terrible audio quality, but if you go to 3:03 in the morning.
Can you speak up, please? I apologize.
Sure. No offense to the court, but I did prefer the older microphone. And if you go to 3:03 in the morning on State's Exhibit 138, which is a dash cam video, Deputy Clark, who was the first officer on the scene, does Mirandize the defendant. It's difficult to hear the responses, but there does appear to be an implicit waiver of his rights. Then Sergeant Garcia and a few other officers do the walkthrough interrogation, which occurs about 2 hours after the defendant's actually first Mirandized. So it's different officers, but it's same scene, same offense, and very short gap in time.
Was this initial, albeit garbled, Mirandizing, was that argued at the suppression hearing?
It was not. It was not mentioned at the suppression hearing, but Deputy Clark testifies at trial that he did Mirandize the defendant. And then when he testifies about what the defendant told him, there is an objection, but that has not, no complaint has been raised on appeal about the introduction of State's Exhibit 138 or his testimony about what the defendant told him.
Was 138 an exhibit at the suppression hearing or the trial?
It was at trial.
Was it admitted?
Yes. So I would urge the court to take a listen to that, see if you can hear what's being said. But I think even if we assume that Miranda does not come into play until what I've been deeming the third statement at the station house, I still think the record supports the trial court's conclusions that he was not in custody during the walkthrough or the initial station house statement. Obviously, the primary problem with the walkthrough is that he is detained for 4 hours in the back of a patrol car in handcuffs. That is a long time. Unfortunately, a lot of the cases that discuss the reasonableness of an investigative detention are in the context of the Fourth Amendment and not really in regards to when the length of a delay triggers the need to Mirandize, or when it becomes custody for Miranda purposes or for Article 3822. As far as I can tell, there is no set time limit at which a detention turns into custody for that purpose. Here, I think it was also reasonable under the circumstances to conclude that a defendant, a reasonable innocent person under these circumstances would realize that they're not being detained for a DWI. This is a potentially fatal shooting, and the officers are conducting an investigation. The victim had to be transported away. There was another witness there who had to be kept separate. So there are certain factors that are happening there which would justify a belief that you're not actually restrained to the degree that's associated with a formal arrest. But it's also significant that the statement is not made until after he's removed from the vehicle, his handcuffs are taken off, and as you've already pointed out, Sergeant Garcia although he does not re-administer Miranda warnings at that point, he does tell him that he would like it if he would give a statement, and he tells him that it's purely voluntary.
Well, let me ask a pragmatic question, and this can just be a hypothetical. How do you paper, digital, or anything else? Is it just the dash cam, the fact that this happened? I mean, what is the SOP in terms of Miranda warnings? I mean, I know what they are with magistrate, but I mean, if you're doing this as the police officer in the field, how is that done? Is it just the fact that some of it's captured, or just the testimony that you gave them? Are there any forms? And I feel like I should probably know the answer to this question, but I certainly am familiar with how magistrates do this and the requirements for that.
I should know the answer as well. I would say that an officer's testimony that he Mirandized him and that the defendant waived that would be sufficient. But if you're looking at Article 3822, then that's where you might need to have the actual electronic recording coming into play. Whether or not a dash cam video is sufficient, I would have to do further research for the court.
Well, and again, I mean, I don't fault you for not having the answer. I just wonder, like with HPD and other things like that, what do they do? That's not necessarily the test, but what their procedures for, because this is obviously a critical point in the investigation.
All I can say is it's the first time I've seen dash cam. Well, that's not true. DWIs, obviously you see a lot of dash cam recordings that record, or body worn camera recordings that record Miranda. This one, if you do go and view it, because of the quality of the audio and the way it is, I don't think it was
And one
intended.
wonders why it didn't come up at the suppression.
Perhaps it's because they couldn't hear the quality of the audio. So that's something that you would need to listen to.
So this would be a dash cam. It would, I guess, it would be pointed forward, but the defendant would have been in the back seat. So all you've got is audio.
The defendant's actually removed from the back seat for this purpose. So he's in the back seat handcuffed, and then because of the angle of the dash cam, you really can't see anything. So you're just hearing. You're just looking at, the house.
Okay.
But then he's removed, and you can hear the officer saying, "I'm going to remove your handcuffs. I'm going to give you your Miranda warnings." He gives the Miranda warnings, and then he also, about 10 minutes later, gets him to sign the consent to search form.
Well, what is the legal effect of the failure to use that dash cam at the suppression hearing, but was used at trial? Does that constitute waiver?
Well, I think that this court, when it's going back to look at whether or not there's some other finding, there's something else in the record that would support the trial court's ruling, you can look at other facts that were developed later.
But what if it wasn't at the suppression hearing? It can't support the trial court's decision at the suppression hearing.
The trial court doesn't say anything indicating that's the basis for her ruling, but I think this court could still look at whether or not there's, considering the entirety of the record, if there's something else that would indicate, well, even assuming that he was in custody, the statement should not be suppressed because he was Mirandized.
How do you respond to counsel's argument that at the time he was placed into the police car, before he made the statement, there was immediate probable cause to make an arrest or Mirandize?
Whether or not there was probable cause is a little iffy. There may have been probable cause for some sort of an offense. But I think what's important for the walkthrough, well, for both of the statements, is that for that fourth Douthit factor, the critical inquiry is whether or not that probable cause was manifested to the suspect. And in here, there is no manifestation. The officers seem to believe everything he's saying. They don't tell him that they think this is baloney. They don't do anything to contradict what he's saying. They certainly don't tell him that he's under arrest. So by all appearances, a reasonable person under those circumstances would not necessarily believe the officers have probable cause to arrest me. And the same would apply with the second station house statement. The officers, even when he admits to the polygraph examiner, I'm not going to be able to pass this test because I'm not going to be able to honestly say, no, I didn't shoot my wife. The response is, well, if you want to tell the truth, then you should go talk to the initial sergeant that he had talked to before. There's no indication that the police were going to arrest him, that they didn't believe any of his claims. So there is no manifestation of probable cause there. I would also just point out for the second statement, he does voluntarily agree to go to the homicide office to give that statement. Obviously, the fact that he's handcuffed during the transportation does not render his statement custodial. And then, of course, the handcuffs are immediately removed. What's most important is that after he signs the consent to give the polygraph examination, Deputy Simmons, who is the one who would have administered the test, specifically tells him, you're free to leave.
And so what does that mean in the context of this? Because I can see that if you're in a room you can't get out of, that somebody says you're free to leave, it's like, okay. I mean, how much does the defendant have to do to test that? And what was the situation here?
Well, here, I think we have to keep in mind he's not handcuffed. There's no other physical restraints. I think we have to give, considering that the trial court gave credit to the plausibility of the officer's testimony, the reviewing court should as well, that when the officer says he was free to leave, he was free to leave, even if, some might argue that in reality it would have been hard for him to get home, or he would have had to have been escorted out. The officer is explicitly saying, you are free to leave. So if an individual is still in custody under those circumstances, it'd be very difficult to ever give a statement without having Mirandized. But
I assume you would agree on some level that merely just saying you're free to leave doesn't cure every situation that could come up factually, when there's other elements there that it's quite clear that you're not.
Yes, and I mean, off the top of my head, if you're in a locked room, if you're handcuffed.
And I'm assuming most interrogation rooms you can't get out of if you're inside. I don't know, never been in one, but.
For this one, at least for the polygraph, he's just in Deputy Simmons' office, and he's even left alone for a minute or two. There's no indication that that door was locked. And I think the testimony was that you may have had to badge in to get into the building, but you could exit through the motion sensor doors without an escort. But I could be wrong about that. But he's not told that he's under arrest, and then when he talks to Sergeant Garcia, he is again told for a second time, do you understand that you are not under arrest, you're not detained, you're free to leave? And he says, I understand. That to me is a pretty explicit indication that he is not in custody.
And did he say that he was refusing then the polygraph? I mean, he initially said that he was going to take the polygraph, and then they asked him a question as to whether or not he could answer as to whether or not he intentionally shot his wife. I don't recall the statement of him saying he couldn't pass the polygraph. Is that in the record?
Right, he doesn't say, there's nothing saying he could not pass it. I guess
right.
The way that it's phrased is during the pre-formulation questions that they're discussing about what they would ask, they haven't actually started the exam. The very first question that Deputy Simmons would have asked him is, are you going to be able to answer no to the question, did you intentionally shoot your wife? And the defendant says that he's not going to be able to honestly answer that question, no. At that point, Deputy Simmons says, if you want to tell the truth, you should go talk to Sergeant Garcia, and the defendant says yes.
And that's kind of an interesting question. I've read a lot of records on stuff like this, and I've never seen that question come up in advance of asking people once they're hooked up to the polygraph and doing it.
Apparently, it is standard to do this pre-formulation part of the polygraph before it starts, and it can take quite a long time in some cases.
And it's likely that testimony just didn't come in on a lot of cases that I've seen. So I would have no reason to know that, but that was interesting.
Exactly. If there are no further questions, I see my time is running out, so I would just ask that the trial court's ruling be affirmed. Thank you for your time.
Just briefly, in response to the idea that Deputy Clark had Mirandized Mr. Olivares, I would just point out that Deputy Clark read the consent to search form, and that language is contained in the consent to search form. However, I would refer the court to the Court of Criminal Appeals' recent opinion in Lujan, which I do not have a citation for because it's that new, but I can give you the court number if you want it, where the PD-0244-19, where the Court of Criminal Appeals held that although Ms. Lujan had been Mirandized at the station, when she is taken in a vehicle to go show law enforcement where the body is, she needed to be Mirandized again because different officers, different circumstances. That statement was determined to be non-admissible because law enforcement should have told her again that she had to purposefully waive her Miranda rights in order for them to continue to question her. Here,
well, hang on, let me circle back. Ms. Hudson argued Exhibit 138. Did I understand you to say at the very beginning that that was simply reading from the...
He's reading from the consent to search form. That's what he was doing. So it had no relationship to the later interrogation by the detective whatsoever. Also, I would point out to the court that there's another case that's in the matter of JJ that is a recent case out of the First Court of Appeals. Again, it's so recent I don't have a citation, but I can give you that court number. It's 01-19-00712, and it's civil because it's a juvenile case. But in that case, law enforcement takes the juvenile into a separate room in the school and tells them, we're going to question you about these circumstances, and after we're done questioning you, you're going to go back to class. So you're not in custody. The juvenile does go back to class after the interrogation, but the First Court of Appeals finds that he was in fact in custody because the police had enough information to form probable cause to arrest him at that time. They couldn't just pretend they didn't have probable cause in order to continue to question him. And they specifically, the law enforcement, their explanation is, well, we needed to get his explanation of the events that occurred. And the First Court of Appeals says, no, there's no rule that says that you get to get the individual's explanation of the events before you have probable cause. And they had enough probable cause to arrest him at that time, so the interrogation was custodial. And that case was a dispositive motion to suppress. So,
what is the significance, if any, of the fact that this audio that Ms. Hudson referred to was not used in the suppression hearing?
Well, I think it wasn't used in the suppression hearing because it didn't matter. They would have had to have Mirandized him again. Yeah, they would have had to do it again.
Under the Lujan case.
Yeah, they would have had to do it again. It didn't have any bearing on whether or not he knew what his rights were at the time of the interrogation. And one other thing, and when it comes to manifestation, I'm not so sure that I think this is all that important, but the state suggested that probable cause had not been manifested. And I just want to point out that manifestation of probable cause can occur either by law enforcement or by the individual themselves. And so when an individual confesses, they have manifested probable cause themselves. There's no reason why it has to come from law enforcement. And I refer you to Meek v. State, which is 790 Southwest 2nd 618. For that rule. And unless you have any further questions, that's really all.
Nope.
Thank you.
All right. Olivares versus State will be submitted, and we are adjourned.
All right.